Let's move to a new concept now, the concept of private and public control. Private control is CC&Rs, deed restrictions. Public control, of course, could be anything such as zoning, or it could be flood control areas set up by the federal or county or state government. What we're talking about here are encumbrances. Encumbrances are things that burden the title to a property. Encumbrances could be money encumbrances, which you voluntarily put on the property, such as a lien for a loan, or they may be involuntary, like a judgment, or the biggest one, property taxes. Encumbrances can be specific, meaning they only encumber that property, or they might be general, meaning they encumber a number of different properties that you happen to own. An example of a specific encumbrance would be a mechanic's lien. An example of a general encumbrance would be an IRS tax levy, or perhaps a judgment rendered by a court of appropriate jurisdiction. All these are encumbrances. They burden the title of property. But they are all that we've just talked about so far are liens. They're money encumbrances. A lien is a money encumbrance. There are also non-financial encumbrances. Non-financial encumbrances are things such as I mentioned earlier, CC&Rs, covenants, conditions, and restrictions for an individual subdivision, or they may be zoning laws, something we call police power, that are put into effect by the city or the county, or in some rare instances, maybe even the state. The term escheat means it's property taken from the private domain and put back into public domain. Escheat is when the state cheats you out of it. Usually you've died intestate, you've left the property to no one, no legal heirs can be found, so after a 5-year period of time, which is statutory, it's put into effect by the state law, the state can seize that property and then sell it if they want to, and the money's put in the state school fund. Usually what happens, properties before they end up in escheat are lost in tax sales because the statute on property tax sales is only 4 years and escheat takes 5 years. Eminent domain is the right of the government to come in and take your property. Well, since we use the alloidial system, which you have private ownership of your property, you're protected by the Constitution. The Constitution, the 5th and 14th Amendments give you certain rights. The 5th Amendment says that your property cannot be taken without you getting just compensation. And the 14th Amendment allows you to have your day in court, that you're entitled to due process of law. So the state or the federal government can come in through the right of eminent domain and take your property, but they must compensate you for it justly. And if you cannot agree on the just compensation, then of course you could appear before a judge and then they would decide if you're getting just compensation or not. Usually the concept of eminent domain is only used for the public good, such as building dam projects or highways, roads. But sometimes eminent domain is lent to quasi-governmental entities such as improvement districts, perhaps irrigation companies, and utility companies in order to run their lines. The concept of eminent domain is enforced by a court action called a condemnation action. So tie the words eminent domain and condemnation together. A floodplain control I mentioned earlier is an example of police power, but then so is zoning. The people that determine the zoning laws are the elected officials. It's not the planning and zoning individual that comes out from the planning and zoning department and says, you can't have a duplex here. They're just enforcing the law, similar to the way that a state trooper pulls you over and gives you a speeding violation ticket. You see, the trooper didn't make the law either, and neither does the planning and zoning person. The laws or the zoning ordinances are put into effect by the elected officials in the appropriate jurisdiction. If you were in an unincorporated area of a county, that would be the Board of County Commissioners. And if you're in a city, under their jurisdiction, it would be the elected city council. They're the ones that determine the zoning. Easements are a type of private restriction, or perhaps an easement was given to a quasi-governmental entity, but it's owned by an individual for their benefit. The person that owns an easement across somebody else's land is called the dominant tenement. The one that has the burden of the easement is called the subservient tenement. Sometimes easements are called easement appurtenant. Appurtenant means it goes either with the land or with the deed. If you have an easement through someone's property and you sell your property, the new owner also owns that easement and burdens the subservient tenement in the other property. An easement in gross is normally associated with utility companies. The utility meter reader can come to your property, walk across your lawn anywhere they want to in order to get to that meter. In the old days, in the 50s, a lot of meters were actually inside the home. And people would leave their back doors open, and the meter reader would come in and yell, "Meter reader," go down in the basement, read the meters, and then walk back out. They were able to do this and not trespass because they had an easement in gross. Easement by prescription is a situation where a property has been used by a person in our state of Utah for 20 years, and then since they've used it open and notoriously, hostile to the true owner, they're going for the continued use of that property. They're trying to obtain an easement by prescription. In order to settle this, you'd have to go to a quiet title action in order to get that easement adjudicated. But if you're buying a property and there's a dirt road through it that's been used for many, many years by everybody to get to a lake or a favorite fishing hole, the chances of you being able to fence that dirt road off because it's your property, even though there's no adjudicated easement against it, may be slim to none if somebody forces the issue and claims an easement by prescription. Easements, remember, are not ownership of another person's property. They're the right to use but not to possess. Just because you have an easement across someone's property doesn't mean you own more property. You only have the right to use it.